The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we'll hear this morning is United States versus McLaurin, and I guess Mr. Macbeth, we'll hear from you first.
Thank you, and good morning, Your Honors. My name is Cullen Macbeth, and I represent the appellant, John McLaurin. Your Honors, the District Court revoked Mr. McLaurin's supervised release and sent him to prison because he violated supervised release conditions with which he was not, in fact, required to comply. This court held in United States v. Rogers and United States v. Singletary that if discretionary supervised release conditions are not orally pronounced at sentencing, but later appear in the written judgment, then they are, quote, nullities that are not part of the defendant's sentence. And those conditions, quote, in fact, have not been imposed on the defendant. In this case, the district court revoked Mr. McLaurin's supervision after finding he violated standard conditions 6 and 10. But those conditions were not orally pronounced at Mr. McLaurin's original sentencing in 2013, and so they are not part of his sentence. The government does not dispute that if a particular condition is not a part of a defendant's sentence, then he cannot be revoked and imprisoned for violating that condition. Instead, the government raises a host of procedural objections, all of which ultimately rest on the same premise, that once a judgment becomes final following the conclusion of direct appeal, any orally unpronounced discretionary conditions in that judgment become part of the sentence, even though they were not part of the sentence before. But there is no legal support for that position, and in fact, this court's case law definitively rejects it. I'm referring to United States v. Newby. In that case, the original judgment contained discretionary conditions that were not orally pronounced at sentencing. The defendant then took a direct appeal and lost, which means his judgment became final. A decade later, when the district court granted a motion to modify the defendant's sentence under the First Step Act, the district court copied and pasted the orally unpronounced discretionary conditions from the old judgment into the amended judgment. This court held that the copied and pasted conditions were a, quote, new part of the defendant's sentence. That is, a term that was not a part of the original sentence, even though the judgment containing those conditions had long since become final.
Let me ask you this, in 2013, Judge Bradar, who was very conscientious, was following what was the law at the time. You read the special conditions, and the rest were just put in the judgment. What you're asking us, I guess, is to reopen his judgment based on the Rogers decision, which, of course, he didn't have the benefit of in 2013. Today, there would be a Rogers error. I think everybody agrees there's a Rogers error. I think the question is, do we go back in revocation proceedings and review earlier judgments?
So, Your Honor, we are not asking this court to revise, reopen, in any way disturb the original 2013 judgment. The judgment is final and it can stay exactly the way it is. And the reason we're not asking the court to do anything to that judgment is that when, as in this case, there is a discrepancy between the oral sentence and the written judgment.
See, back then, though, that wasn't considered a discrepancy. If the judge says you have to go to a rehabilitation center every 3 days, and then the judgment says 5 days, that has to be resolved, and in those days we always resolved it in favor of the oral. But there was never a requirement to read or impose the conditions, except the special conditions. And there was a judgment, a written judgment signed with everything on it, and he had that judgment. So at that time, the judgment was not erroneous. We recognize under Rogers, it would not stand up. So my question really is, whether we should be going back and opening up earlier judgments. I mean, that's basically what you'd be reviewing it, because today, I mean, back then, the judgment was written, was pronounced orally, and it was written on paper, and everybody had access and knew what the conditions were. They just had to read the paper.
Correct, Your Honor, and certainly, we're not criticizing Judge Berdar. No one back then knew that Rogers was going to come along, so there's no mistake, on the part of Judge Berdar. But again, we're not asking the court to do anything to the 2013
No,
judgment.
you're asking us to declare the conditions which were imposed legally in the judgment back then. You're saying those conditions shouldn't be imposed,
Well, but Your
which
Honor,
is basically reviewing that judgment and changing it.
respectfully, I disagree, Your Honor. The point of Rogers is those conditions were never imposed. They weren't imposed.
Well, that's what Rogers and Singletary says, but that was not the law back in 2013.
No, Your Honor, but there are many cases that this court has decided after Rogers where judgments where the defendant was sentenced before Rogers, nevertheless, after Rogers, he has his direct appeal and says those conditions, there's discrepancy, and this court corrects them, even though at the time the judgment was entered, the law was different. So this court has never said that just because Rogers was not on the books when a judgment was entered, that somehow that rule that Rogers announced later doesn't apply. The court has done that many times. It has applied Rogers to cases where the judgment was entered before Rogers came out. And so we're asking this court to honor what the sentence has always been. The sentence has always been the oral sentence, which is one that does not include these standard conditions.
In the cases that you're discussing where we found that the Rogers error existed before the Rogers decision came down, was the issue raised at the revocation hearing? I wonder why here, the 2 days after the revocation hearing, was when the appeal notice was filed, and for the first time the Rogers issue was raised on appeal, where the revocation hearing took place 2 days earlier. Why didn't at that point during the revocation hearing, why wasn't the Rogers issue raised then?
So to clarify, Your Honor, when I said that this court has decided Rogers cases where the judgment was entered before Rogers, I'm talking about cases not where there was a subsequent revocation hearing, but where the first direct appeal was filed, held in abeyance for a long time, and then subsequently, after Rogers came down, the court addressed the Rogers error. As for why the error was not raised below, I don't know. I think probably everyone just missed it. That happens sometimes, and we certainly acknowledge that it wasn't raised below, and therefore plain error applies. So we are required to satisfy the 4 prongs of plain error, but we think we've done that in this case. We think.
Mr. Counsel, is it retroactive? Is Rogers retroactive? Yes or no? Is it?
Yes.
But that's why I'm saying, I'm surprised why you just say so. It's been applied retroactively in the Fourth Circuit, correct?
Correct, many times, Your Honor. Yes, this court has I don't have a list at my fingertips, but there are many cases in which this court has said that Rogers applies to judgments that were entered before Rogers. And this is also relevant to the mandate rule issue that the government raises. The government says the mandate rule applies here because the first judgment in 2013 somehow made it settled that the orally unpronounced discretionary conditions became part of the sentence. But first of all, Newby makes clear they did not become part of the sentence. So the mandate in the first case didn't settle that. But even if the mandate somehow settled that from the 2013 appeal, there is an exception to the mandate rule for when there's a change in law that gets applied retroactively, to your question, Judge Gregory. So
Why isn't this just invited error? Your client, there were, as my understanding, many issues. 5 and 6 were the only ones that were based on what you now say are null conditions. The other alleged violations were all conditions that were lawfully imposed. So your client, at the revocation hearing, agreed that there had been violations of the null conditions. The government waived, I assume, any argument that the first 4 that were valid conditions had been violated, and that was the basis of the agreement. And that seems to me to invite the error, the exact error that you're raising here on appeal.
So no, Your Honor. What Mr. McLaurin did is he admitted that he engaged in the conduct underlying those 2 conditions. He did not ask the court to revoke his supervised release, and he certainly did not ask the district court to send him to prison. So by analogy, think of the McKinney case, which we cite. In that case, the defendant pled guilty to the 924C count, and other charges were dismissed. Nevertheless, on 2255, he was able to get relief because the predicate underlying the 924C was invalid. This court did not say that he had somehow invited the error by pleading guilty to the 924C count. He simply pled guilty, and there's no invited error there. It's the same way here. He admitted that he engaged in the conduct, but he did not ask the court to revoke his supervision.
But there were other violations that the government did not pursue. Is that right?
Yes.
And those violations were violations of admittedly valid conditions that had been imposed in 2013.
Yes.
So what are you asking us to do now at this point?
I'm asking the court to vacate the 2024 judgment that revoked Mr. McLaurin's supervised release because it's based on finding that he violated a condition that didn't exist. It was a condition that was not part of his sentence, and therefore it cannot serve as a basis for revoking his supervision. And again, the government, doesn't really dispute that. They do not dispute that if the condition was not part of his sentence, he cannot be revoked for violating it. That seems to be common ground. The government's objections are all procedural. They argue that the conditions actually somehow became part of the sentence after direct appeal was over. But again, Newby definitively rejects that argument. In Newby,
So if we were to do what you're suggesting, we would then be sending it back to the district court for a do-over, essentially a new revocation hearing based on the lawfully imposed, the violations of the lawfully imposed conditions?
so I think the remedy is to remand, to vacate the judgment from 2014, remand with instructions to dismiss the petition, which is what this court did in a published decision issued earlier this year called United States v. Wheeler, where the government, the district court erroneously admitted certain evidence under Rule 32.1, and this court remanded and said to vacate the revocation judgment and dismiss the petition.
What about the conditions that were lawfully imposed, according to you, in 2013?
So if Mr. McLaurin had admitted to violating those conditions, then we wouldn't be here.
No, that was a deal. I mean, he admitted that, and the government didn't pursue the others.
But Your Honor, that's true in every plea agreement. Again, that
I
was,
know, but if you wanted to, if you're going to have us undo the deal, you can't hold the government, force the government to now give up its arguments. It's going to then press the ones that were legitimate.
So in a case called United States v. Adams, which this court decided in 2016, the defendant filed a 2255 long after he had pled guilty, in which other charges were dismissed, and this court granted the 2255 because the 922G1 predicate was invalid. And the government said, ask this court, okay, remand and let us reinstate the original indictment so we can pursue those other charges.
But conditions of supervised release are different. They're not, the district court at any point can impose new conditions of supervised release so long as there's a new hearing. So even if, what the district court could do here, I think, is under Rule 32.1, simply modify the conditions of supervised release.
Yes, absolutely, Your Honor. We agree. So if the case goes back, the government or the probation officer or the court by itself could file a motion to modify Mr. McLaurin's conditions, and the court could then add the
We'd be right
conditions.
back where we are then.
Yes, going forward, absolutely. The government.
I mean, we're on plain error, aren't we here?
Yes, Your Honor.
I mean, so if we end up in the same place, would hardly satisfy the plain error standard.
Well, the error has already happened. The modification hasn't happened yet. So the hypothetical modification that may or may not come to pass can't, cleanse an error that's already occurred.
So there wouldn't need to be a complete, I suppose there would need to be a hearing, unless it was waived, to impose new conditions of supervised release that were the conditions that were standard conditions that were, you're saying, are a nullity based on the retroactive Rogers application. The court could then reimpose or impose them properly, and then at that point, there could be a revocation hearing based on those violations.
Well, going forward, there could be. I mean, yes, we can. If the court remands, the district court can then modify supervised release to add those conditions. I don't think Mr. McLaurin could then be revoked for having previously.
Although he could be revoked for the violations that the government didn't pursue in the prior revocation hearing.
In theory, yes. Again, I think under the Adams case that I was just describing, where this court said, no, we're not going to reinstate those because that's vindictive, I think probably, there's a due process question there. But the court can just sort of assume, for sake of argument, that yes, on remand, there could be a new hearing, but that just, that means the parties can address that on remand. It's not a reason not to find an error here. There was an error. It's a clear error. It resulted in Mr. McLaurin going to prison, so it satisfies the third prong, and it also impugns the fairness and integrity of judicial proceedings and public reputation if we're sending people to prison for engaging in conduct that they were not prohibited from engaging in. I mean, that's the question at the fourth prong. Would the public have a diminished view of judicial proceedings if it knew what was happening here? And I think the answer is yes. I'm sorry, Judge Gregory.
Well, that was the purpose of Rogers itself, the Supreme Court, and that is, you shouldn't be a sentence that was not properly, given, right? And so it reached even the fourth prong of clear error.
Correct, and what happened here is, again, Mr. McLaurin was sent to prison for doing something that he actually was not prohibited from doing. And I think if the public knew that people were being sent to prison for engaging in conduct that they are actually allowed to engage in, people would be very troubled by that. That absolutely affects the public reputation and integrity of judicial proceedings. And so all four prongs of plain error are satisfied. Unless the court has more questions, I'll save the rest of my time for
All
rebuttal.
right, thank you, Mr. Macbeth. All right, Mr. Medinger.
May it please the court, Your Honors, my name is Jason Medinger. I'm here on behalf of the United States. Your Honors, the defendant here in this case is seeking to violate the bargains that he struck with the government. He's trying to violate the bargain that he made at the revocation hearing where he admitted to violating these conditions, which he now says are nullities. He's trying to violate the terms of his plea agreement. And what he's trying to get for himself is essentially a get-out-of-jail-free card that says he can violate with impunity any standard supervised release condition that's in his judgment. This court should have no part of this.
I didn't hear counsel argue that at all. He didn't say that at all. I mean, I know you're counsel for the United States, but it's hyperbole in terms of how you represent the argument. What he's saying is that the Supreme Court said this is a Rogers error, and that's why it's retroactive, because you can't bargain away what was not a legal sentence. So that's what he's saying. He's not saying get out of jail. Matter of fact, I thought counsel was very respectful in terms of even the court's questions, like things that really the district court will have to decide later if it's remanded. That's nobody says how to get out of jail free card. I mean, matter of fact, in terms of supervised release, sometimes it's more shackling than others, and people can't get jobs, they can't get to things like that. It becomes a sword of Damocles over their head. So I don't think that's argued at all. Instead, the question is, I'm going to ask you, isn't Rogers in this court say it's retroactive?
So we have applied Rogers on direct appeal retroactively. Right. So someone has a judgment. They say there's new conditions in my judgment that I was not aware of. On direct appeal, this court certainly has corrected Rogers' error. No question. That even applies to cases that the original sentencing happened prior to Rogers. Right. We are here in a fundamentally different posture. We are here now on, 10 years after the judgment. We are here after Mr. McLaurin has foregone any ability to appeal. He's violated Federal Rule of Appellate Procedure 4. Really what my colleague, I hope he'll address on rebuttal but didn't hear, we have to talk about Brantley. Brantley, in our view, decides this case. So this court held in Brantley that a Rogers error, a plain and obvious Rogers error, can be forfeited if you don't raise it on direct appeal. Here, we are well past that. Yes, sorry, Your Honor.
What about Newby? Wasn't Newby years after the Rogers error, and in fact, the Rogers error took place before the Rogers decision?
So it certainly was, Your Honor. Here's the difference on Newby. Newby had a new judgment. In other words, they had a new amended judgment after the First Step Act, and it was a new error. In other words, they did a new Rogers error in creating the new amended judgment.
Well, didn't the district court here do the exact same thing when it reimposed the same conditions at the revocation hearing? The district court did the same thing here. There was a new Rogers error at the revocation hearing.
So, Your Honor, that is actually not being challenged here. In other words, Mr. Macbeth, as I understand it, is not challenging the supervised release conditions that were imposed at the revocation hearing. He's going all the way back to 2013. That's why we say he's got a Brantley problem and a Federal Rule of Appellate Procedure 4 problem and a law of the case problem and an appellate waiver problem. He's going all the way back in time to 2013 because there was not those kind of errors in 2024. As you said also, those were invited errors. They admitted to those violations. But this is not a direct appeal of supervised release conditions raised in 2024. This is going back to an error that happened a decade ago.
Can we address the supervised release, Rogers issue from 2024?
So, Your Honor, I think the argument has been waived, so I would say at this point you cannot. That's not something that they are challenging. I do want to go to Brantley, though, because I think the language in there is quite important for this case. So what Brantley said was, even the most obvious Rogers error, the one that is clear as day, if an appeal is not taken at the appropriate time, it becomes part of a valid and binding judgment. And that's the words that we rely upon here. The judgment of 2013 is valid and binding. That's the rules under which we have to operate. And there simply is no basis at this point to go back and do it. Brantley involved an individual who didn't file appeal for 223 days. He was 223 days late. Mr. McLaurin is a decade late. There's no way to resurrect that claim. The other problem with these claims of raising these kind of errors at the revocation hearing, it also would violate this court's precedents in Sanchez and Johnson. And so this court said you can't wait till a revocation hearing all the way at the end to go back and try to challenge supervised release conditions that were imposed at your original sentencing. And that rule makes a lot of sense. When you see an error, you have to raise your hand and try to correct that error as soon as possible. You can't wait until after you violated to say, well, it was a nullity in the beginning. And that's what's the defendant is trying to do here. So to get to
So you
where—
wait until the day after the Supreme Court case came out? After the day after it comes out?
And sorry, Your Honor, I didn't—
When do you wait? When Rogers came out, you do it immediately? After that comes out?
So our contention, Your Honor, would be that in 2013, Mr. McLaurin had to essentially raise what is now a Rogers claim to preserve it, and he did not. That claim could have been raised, and it was not.
Well, then,
That wasn't the law then, was it? As Judge Niemeyer pointed out, that wasn't, people, they send us all the time, say, look, we'll get this straight, you'll get the written terms later. They didn't know that what you said orally was gonna be that binding in terms of a valid sentence, so you can't have it both ways there.
Well, Your Honor, I think the person that's trying to have it both ways here is frankly the defendant. Instead of calling it the Rogers doctrine, we could have called it the McLaurin doctrine. He could have raised these claims. He could have been the person that blazed that trail. That argument was available to him. And again, we look at this court's precedent going all the way back to 1965, United States versus Morse, talking about if there's a difference, a discrepancy between the oral pronouncement and the written judgment. These claims were certainly there, they just weren't raised. And so that's why under Brantley, they're waived by, again, a matter of a decade.
I'm looking here at Brantley, and it doesn't seem to me to say what you suggest it says. It does say that the judgment stands, which is exactly what your colleague on the other side said. He's not challenging the judgment itself. But what it does say is that the conditions that were imposed improperly are nullities. So the judgment stands and is presumptively valid and binding, but it doesn't say that the conditions that were unlawfully imposed are included in that judgment. It just suggests that the judgment exists without the nullities, which is, I think, exactly what your colleague is saying. He said specifically he's not challenging the 2013 judgment, only the revocation that are based on null conditions.
So Your Honor, I want to suggest that I think what in fact he is doing is challenging the 2013 judgment. That's the only way he gets there. The only way that he has an argument about 2024 is to first make a facial attack as to 2023.
As to the nullity aspect of it, the nullity, not the whole judgment, just the fact that it's a nullity, it's sentence, that part of the revocation terms is a nullity. That's all. It's a dissection. It's not a complete radical removal.
Well, again, that's I think what frankly the defendant is asking for. This goes to Judge Niemeyer's question. Are we going, when we say the judgment is valid and binding, the whole thing is valid and binding? The whole thing, which includes the supervised release conditions.
That's not what the case law was. Judge Berner just read you. It said that, yes, it is the judgment, but the nullity aspect, a nullity, a legal nullity means it never happened. It's null and void, that part of it. That's the only part, and that's what Rogers deals with. We do it all the time. We do, you know, you just look at the number of Rogers cases that we have. They just go through, they're not oral arguments. They normally handle in a different manner. It's the same thing, that part of it, because the law requires you to, you know, and that's what our framers did about a constitution. What makes us such a rare country, and that's important, that you ought to know what you're being sentenced for and being told, and that's what the Supreme Court said. That's not happening now. It's no fault to any judge who didn't do it before, but it is a way of cleaning up and being a better representation of what the Constitution protections are. It's just that aspect of it.
So I understand that 100%, Your Honor, and actually I agree with it. We do have to inform individuals of what they're going to be bound to. Our argument here is that he was informed in the written judgment, and if he felt like there was some discrepancy that he had to raise it a very, very long time ago. And I would say to the Brantley question, you know, essentially this is a forfeited claim. In other words, if you have an issue with your judgment, you have to raise it in a timely way. If you don't, your judgment then becomes calcified. It becomes locked in amber. That now is the judgment that you have to abide by.
Time does not ripen a nullity.
Well, again,
I said,
say.
You disagree? Time does not ripen or improve what is null.
So I would disagree with that, Your Honor.
Tell me how something that is legally null and void over time becomes somehow, life comes into it again.
So, Your Honor, there's all sorts of, and I look at it in the context of error. You know, errors happen with
Errors are different. That's in terms of making a judgment about something, you made an error. But when it's declared a nullity, it's null and void. I'm asking you again, how does it revive life over because time passed?
So what I can look at, Your Honor, is a number of contexts where this happens, and we are okay with this.
All right, go ahead.
So let's look at, you know, Rule 35, for example.
Mm-hmm.
You know, there are errors in judgments that can be corrected under Rule 35. The window is very narrow.
Mm-hmm.
If you don't do it, you've waived it. Rule 35 has been determined to be jurisdictional. And so that Rule 35 doctrine, which has been accepted by this court and others, that says if you miss a window to challenge something in your judgment, even if it's the most obvious error, we're not going to let you go back and correct it.
Where in your example you just gave me, something was already declared null and void.
So, Your Honor, again,
it's just an error that was passed over. I mean, give me an example where something is declared null and void and is revived.
Yeah, again, I think.
I don't think you can.
Well, Your Honor,
I don't think you can.
Your Honor, what I would say is,
okay,
if you follow the logic of Brantley, once a condition is imposed, even if, again, using the words of my colleague, if it's a nullity, if it's something that wasn't orally pronounced, it becomes part of the judgment after.
It's not the term of your colleague, it's the term of our precedent. And in fact, what Brantley says is that those conditions are null, that the judgment stands, but those conditions are null. And then again, in Newby, we said the same thing. And in Newby, the judgment, although the judgment stood, those conditions were null. And that was our term, the nullity term. And specifically in Newby, we said that those, because those conditions were never imposed in the first place, they could not be carried forward through the district court's amended judgment. And so they were null at the time they were imposed.
Right, so I guess, Your Honor, and here's where I'm trying to square the circle. In my view, Brantley would have to come out a different way if that is entirely the right answer. In other words, Brantley would have said, even though you've waived this argument under Federal Rule of Appellate Procedure 4, the ship has sailed, it's a nullity, so therefore we can go back and correct it. Or we can make sure that you're not held to that. We can excise that out of your judgment. But that is not what this court held in Brantley. So in my view, I can't square those two. You have to say, I think, if Federal Rule of Appellate Procedure 4 means if you don't raise the issue, you've waived it, and it's now part of your judgment forever, on direct appeal, certainly now that we're here in this context, I think the answer has to come out the same way. I just don't see a way to do it otherwise. I could switch gears just very briefly to talk about one other issue, and that is our appellate waiver argument, because I would like to talk about that for just a minute, because I think, Judge Gregory, some of the questions you had about this is, well, Rogers wasn't the law at the time. And there is a very defined path of precedent, if you will, that indicates that an appellate waiver is going to be good even when there are subsequent changes in the law. And so here we had what I consider to be a zipper clause appellate waiver. It's any issue that relates to, in any way, the supervised release conditions. That was the bargain that we struck with the defendant. We agreed to dismiss a 924C charge and a 924O charge. That was the benefit of our bargain. And now here we are having to deal with an appeal related to an issue that relates to a supervised release condition. And so we've cited cases indicating that appellate waivers do apply to supervised release conditions. That is, I think, uncontroversial. And so under our appellate waiver, even if you say under Federal Rule of Appellate Procedure 4, we're going to allow this claim, certainly under our appellate waiver, it's a matter of contract between the parties. We negotiated for global peace, and yet here we are on appeal with a defendant who admitted to these violations at the revocation hearing and now still wants to take an appeal and void essentially all of his supervised release conditions. That to me is the government not getting the benefit of its bargain, and we respectfully ask this court to enforce the waiver here. And I think that's another ground on which this court can and should affirm. The last point that I'd like to make, unless there's any further questions, is just to recall that we're here on plain error. And so if we get through the prongs of plain error, certainly on the second prong, the defendant here has to show that the error is plain. And what I would ask is, rhetorically, what case applies Rogers in this setting? In other words, we're not here on direct appeal. We readily agree that there are a plethora of Rogers error cases on direct appeal. But if we're talking about the plain error context, what case shows that this kind of error is going to be plain at a revocation hearing that takes place a decade after this judgment was entered? I'm not aware of any such case, and I don't think my colleague has cited any of those cases either. So we'd respectfully submit that this error was not plain. And then we go to the fourth prong of the plain error analysis, and this goes to whether there was a miscarriage of justice, the fundamental fairness of what was imposed here by the district court. And in our view, it's fundamentally unfair to allow a defendant to get to a revocation hearing to say, yes, I fully admit that I violated conditions 6 and 10, and then 2 days later, as you said, Judge Berner, to file a notice of appeal, and here we are saying, oh, they were nullities all along. That, to me, undermines the fundamental fairness of judicial proceedings. They led Judge Berdar down the primrose path to say, you can revoke me, I did it, I admitted it, and then here they are arguing to this court something very, very different. And that, to me, is a failure on the fourth plain error prong. And so I think that's another reason that we respectfully ask that this court would affirm.
Okay.
Thank you, Your Honors.
All right, thank you, Mr. McBeth.
Thank you, Your Honors. A couple of quick points. I'd like to start by addressing Brantley. The factual context of Brantley is that the defendant filed his notice of appeal 223 days after the deadline, after the judgment was entered. And he argued on appeal that because there were nullities in the judgment was, quote, invalid on its face and automatically moot. In other words, it was as if the judgment had never been entered at all, as if there was no judgment. The whole thing was void, and therefore the 14-day clock in Rule 4 never started to tick. That is the only thing this court addressed in Brantley. Brantley did not hold that even after when a judgment becomes final, orally unpronounced conditions become part of the sentence. And we know that because Newby cited, relied upon, and affirmed the holding of Brantley, and nevertheless held that even after a judgment is final following direct appeal, orally unpronounced conditions in that judgment are not part of the sentence. So Brantley does not help the government here. Second, the government was suggesting that Mr. McLaurin forfeited this issue because in 2013 he should have filed a direct appeal raising this issue. But this court has already squarely rejected that argument in the Sissing case, which we cite in our reply brief. In that case, the briefs were filed, and after the briefs were done, Rogers came out. The defendant then filed a 28J letter raising the Rogers issue. The government said it wasn't in the opening brief, you've waived it. This court said no, Rogers wasn't available until after the briefing was filed, so you can't waive a case that isn't even available to you. And importantly, the court said that is so even when the new case does not mark a dramatic departure from existing law. Even if it doesn't upend previous law, even if it just extends previous law, you still can't waive that case just because you didn't raise it in your opening brief. So to suggest that in 2013, Mr. McLaurin.
The issue was raised in Rogers. Why couldn't that same issue have been raised by counsel in this case? In other words, if the defendant was upset that the conditions were in the judgment but had not been announced in court, he could have raised that, but more pronounced is that when he's brought to court under those conditions that were in the judgment, the written judgment, he reaches an agreement that says, okay, government, you don't press conditions 1, 2, and 3. I'll plead to conditions 4 and 5. And the court says fine and imposes a new sentence, which has been served the 90 days, and he's now on a new terms of supervised release. It looks like everything's sort of passed. I mean, the first thing that comes to you is a certain sense of mootness. We're challenging conditions of supervised release that are no longer applicable because he has new terms of supervised release. We have sentences were served. There was an agreement reached. Nobody's talking about Rogers at any point. And now on appeal, we have to go back through all of that. I mean, even the original sentence was the subject of a plea agreement where the government gave up some things and you got some benefits.
Sure. So, Your Honor, a couple points. So, first, to your first point about Mr. McLaurin could have put together the Rogers argument in 2013, the government made that exact argument in Sisson, and the court rejected it. It said that the defendant is not required to, quote, break new ground by raising the Rogers error, and that it would, quote, blink at reality.
Well, I understand that, and I understand that as a pragmatic matter.
Okay.
But even after Rogers comes out, it sits there pretty plain, and we don't hear anything about it. As a matter of fact, we hear about a deal, and the deal then really abrogates all the original terms and imposes a 90-day sentence plus new terms of supervised release, which he's under now and which are not being challenged. And so I understand your argument. There's a lot of logic to it, but
so Your Honor, if you're
there's a notion of finality and mootness and ultimate effect on him. There's hardly any effect on him. He's under new terms of supervised release now, which are not being challenged, and so it's almost academic.
So on the mootness point, Your Honor, this court's case law in the case called United States v. Ketter holds that even after a defendant has served the imprisonment term imposed on revocation, a case is not moot as long as he is still on supervised release. If he had finished both imprisonment term and supervised
I'm not
release,
arguing moot. I'm invoking or suggesting the concept of it because nothing that you're challenging is in force anymore. The original sentence was served, the incarceration was served, the supervised release has been displaced. There was a Rogers error there. He agreed to revocation, got a new sentence, has new terms of supervised release. And my point is, it seems like it's a bygone.
so if your point is that the practical real-world consequences are fairly minimal in this case, I'm not going to dispute that. But the way the case law...
I'm just trying to find out how does it affect him at all?
Well, because he served, so to go back to the mootness point, the reason a case is not moot when someone still has a supervised release term to serve is that on remand, if the defendant says, look, the Fourth Circuit vacated my revocation, he could then move to reduce his term of supervised release, the length of it, for that reason. So that's what's, at stake here.
What is the current term of supervised release?
Well, following the revocation
Yeah,
judgment,
the revocation, yeah.
the court imposed 42 more months of supervised release.
42 months? Yeah.
Yes, so I believe he's done with supervision in January of 2027. I'm not sure
Okay.
about that. But just last point on the sort of effect on the prejudice, which is, I think, part of what you're getting at. We cite McKinney in our case, in our brief, but the more on-point case is one we cite in our reply brief, Doswell, which is a supervised release case where the court did the prejudice analysis exactly the same way the court did in McKinney by saying, no, we look only at charges that he actually pled to, not charges that were dismissed.
Okay.
Thank you, Your
Thank you
Honor.
very much, yeah. We'll come down and greet counsel. Mr. Macbeth, you were court appointed, and
No, Your Honor, this is our client.
well, I was going to give you a lot of credit for being court appointed, but I still give you credit for being an effective lawyer.
Thank you, Your
Thank
Honor.
you. We'll come down and greet counsel. All right, next case we'll hear is Bomar versus Board of Education, and I guess Mr. McCormick will hear from you when you're ready.
May it please the court. Corley McCormick Jr. of the McCormick Law Firm, on behalf of the appellants who
We're
are plaintiffs
across the
below.
room here, so I know you have a microphone, but just keep it up a little bit. Speak so that we can hear more clearly.
Yes, Your Honor.
Appreciate it, yes.
And Your Honors, my clients are listening in by audio, and they wanted to let the court know that they are intently listening to this case. Of the 95 participants in the 2019 reduction in force process at the Harford County Public Schools, only 4 of the assistant principals were African American women above age 40. After the reduction in force process, 0 African American women above age 40 were retained by the school board. This was despite concerns which were initially raised by the Assistant Superintendent for Human Resources and additional concerns that were raised by former school board members. Those concerns were ignored and a legal process was implemented, and it's well documented that all 4 of the assistant principals were highly effective in their roles and were demoted and not restored for discriminatory and retaliatory reasons. The lower court erred in determining that the plaintiffs failed to present facts or evidence of pretext in response to the defendant's so-called legitimate non-discriminatory motives. The lower court, unfortunately, gave the defendants the benefit of the weight of every fact and every inference in their favor. There are evidentiary standards to determine whether pretext is acceptable before the court, and the recent cases from this court demonstrate that plaintiffs can establish pretext through 2 routes. First, by offering evidence that the employer's justification is unworthy of credence, and secondly, by presenting other forms of circumstantial evidence that are sufficiently probative of discrimination, and that was reestablished in the case of Wanamaker Amos versus Purim Novi, which was recently decided by this court in 2025. Also, in Wanamaker Amos, this court determined that the plaintiffs presented, in that case, evidence of falsity of the employer's non-discriminatory reasons for the adverse action. They also presented the employer's shifting and conflicting reasons for their determination and the employer's failure to follow disciplinary policies. And that was in an employment case. Here, this is a reduction in force or RIF case, not discipline, and the employer in this case failed to follow the reduction in force policies. An even more recent case, this summer from the court, that's Hollis versus Morgan State University, determined that the plaintiffs may present circumstantial evidence that the employer failed to follow its own internal policies. The deviations themselves, according to the court, are circumstantial evidence from which pretext and discriminatory intent may be inferred.
So what exactly is the circumstantial evidence that you are alleging the district court failed to take into consideration?
Thank you, Your Honor. There are two types. The first type would be the process type of circumstantial evidence, and that would include the violation of the procedures, including the RIF policy, the violation of the contract, the use of, and then there's, I'm sorry, Your Honor.
So you're not arguing that the RIF policy itself is evidence of pretext? You concede that organizations can engage in reductions of force?
Oh, yes, yes, Your Honor.
So you're not challenging the policy itself? You're arguing, as I understand it, that the policy wasn't followed?
Thank you, Your Honor. Yes, the policy was not followed. In fact, there was an entirely new process that was implemented to supplant the RIF policy.
So there was one RIF policy and then another RIF policy substituted for that RIF policy. But what evidence is there that the substitution of the RIF policy was in any way pretext for discrimination?
Thank you, Your Honor. So the first policy required the defendants to consider qualifications, performance, and tenure, years of service. The replacement to that policy, one, it was never written or documented with respect to the deliberative process. Well, let me step back just a moment, Your Honor. The requirements for the applicants was documented. The applicants were required to submit to an interview and to submit resumes. The deliberative process, how the interview, and then there were additional documents, supervisory references, and what was termed a top 5 list, those were also included in the process, and the decision makers had those, and they were included in the process. There was never any documented rubric for how or if the defendants were required to consider all the evidence in the process.
Does our case law require that the RIF process be documented?
No, it doesn't require.
So why is that evidence of pretext?
It's evidence of pretext, Your Honor, because it allowed for the defendants to discriminate against the plaintiffs. And they would not have been able to do so had they followed the original process.
So are you saying that the new process allowed more subjectivity?
Yes, subjectivity, but also it was just completely arbitrary, Your Honor. So, for example, the defendants could have considered the interviews and the interview scores. They could have considered the supervisory references. They could have considered the top 5 list, but they weren't bound by anything. And again, since it's documented there, you'd be hard-pressed to show anywhere that how the defendants actually conducted this process. The only way we were able to discern it was through the depositions and piecing together other bits of evidence.
Now, how did the prior process for RIF shore up those things and prevent what you say that opened the door for the subjectivity?
Okay.
Tell me, yeah.
Yes. So by limiting the process to qualifications, performance, and terms and years of service, the plaintiffs would at least have been on notice that their performance, for example, would have been important in the process. According to the defendants, and I think there were several different depositions, there was really only one measure of performance, and that was the annual evaluation for the plaintiffs, for the assistant principals. We know that all 4 plaintiffs were deemed highly effective during their tenure at Harford County Public Schools. So we would submit that for performance, they certainly would have been deemed worthy candidates and high in the process. Secondly, with respect to terms and service, there were a lot of individuals who were far younger with less experience than the plaintiffs. So we're certain that we believe that the plaintiffs would have been able to demonstrate that had they used the original process, that especially someone like Janice Stallings, who had been there for, I believe, over 20 years, that because of her term of service, because of her performance, and certainly the qualifications, she should have been high in the process, in the rankings.
All right. So your position is that when you take out things like performance and qualification and years of service, that's to the detriment of persons who are older and been there longer?
Yes, Your Honor.
Because then you don't have to use those, you can use other things. That's your argument?
Yes, Your Honor. So, Judge Berner, going back to your argument, there were two, going back to your question, there are 2 separate pieces of types of evidence. The first would be the process type, and then the second would be the individual comparative type evidence, and that would be, one, the comparators that the plaintiffs included, and then also the supervisory references.
Can I ask you about your retaliation claim? Isn't it true the plaintiff's EEOC charge was filed after they learned that they had been demoted?
Yes.
So how could that be the basis of retaliation?
Okay. Your Honor, so the retaliation claim includes the refusal to reinstate the plaintiffs shortly after the process, as well as the continuing refusal to reinstate the plaintiffs, for one. But also, Your Honor, the plaintiffs notified.
So your argument
themselves.
is that the retaliation wasn't the failure to appoint them as assistant principals, it was the failure to put them in those positions after they complained?
It was the failure to reinstate them to the positions or replace them in the positions. They had the school board had the opportunity to do that because this is not a termination case. The plaintiffs were not terminated.
I understand,
they were demoted.
but essentially
so
what you're arguing is that it was retaliation not to settle, or not to reach an agreement after a complaint was filed.
the argument is what you originally stated, Your Honor, which is that after the plaintiffs were demoted from their positions, they were not reinstated back to those positions. So it was just a continuous violation. Well, I don't want to say.
There was a pool right afterwards?
Yes, there were several pools.
And they filled, 4 more positions from the pool?
During, I think, 2020 or 2021, but there were additional positions each year.
But the pool remained open for 3 years, right?
Yes, the AP pool.
And there were 4 more assistants during that period that were appointed from the pool. If the candidate didn't succeed the first time, then you could be in the pool, right?
Yes, correct.
And then they had the pool, and if I understand correctly, they appointed 4 more.
There were at least 4.
Yeah.
I don't.
And of those 4, 2 of them were African American.
There were 2 African American women who were appointed. However, One of those individuals was Monisha Thomas, and she and in that particular process, Robin Bomar was the #1 candidate for the position, and the school board has asserted through their superintendent, through their executive directors, that that was their #1 goal, was to grant the principals their top choices of candidates. But when it came to Robin Bomar, after they had filed after they made their claims of discrimination known, then the process changed yet again. And it was determined that this particular school needed a science teacher, which just so happened to not be one of Ms. Bomar's specialties. Also, as it turns out, the candidate for that position, Monisha Thomas, she remained for 1 year, and then they replaced her with an individual who had the exact same qualifications as Ms. Bomar.
So your argument with respect to the Aberdeen High School position is that the requirement, the imposition of the requirement of science background is evidence of pretext? Is that what you're claiming?
Not that it's the shifting rationales for the decision, Your Honor.
Okay. We'll hear you some more on rebuttal.
Thank you, Your Honor.
All right, Mr. Constas.
Thank you, Your Honors, and may it please the Court, Adam Constas, on behalf of the appellees, the Board of Education of Harford County, and Superintendent Dr. Sean Bolson. I'm here today to request that this Court affirm the decision of the U.S. District Court for the District of Maryland to grant summary judgment in favor of the appellees with respect to appellant's employment discrimination and retaliation claims. The District Court granted summary judgment in favor of the appellees because the appellants failed to set forth any genuine disputes of material fact as to whether the legitimate non-discriminatory and non-retaliatory reasons asserted by the appellees were false, any pretext for discrimination and retaliatory motives. In other words, the district court found that the appellants could point to no facts in the record that were probative of that ultimate question in any employment discrimination case, which is a discriminatory or retaliatory motive. That ultimate question is the right question to ask at the summary judgment stage, because there must be some fact in the record upon which a jury or fact finder could make such a finding, and there are none in this case. I'll address some core facts which are not disputed. It's undisputed that due to a looming budget gap, the superintendent decided to exercise his statutory authority under Maryland law to reassign staff as the needs of the school require. This was a reorganization and reshaping of the second level of school-based administrator positions, which included assistant principals and instructional facilitators. He directed HR to develop a process for making assignments rather than using an existing reduction in force process, because the goal was not to reduce the overall size of the workforce, it was to reorganize school-based administrative staff and create strong school-based teams in that reimagined assistant principal position. And the superintendent testified that the existing annual performance evaluation tool was not meant to be compared across supervisors and across candidates. He questioned how length of service was to be calculated under the existing RIF process, and importantly, the superintendent wanted to give principals an opportunity to have a say into the formation of their school-based teams, and the RIF process did not serve those legitimate interests. The selection process that was used involved the following components: the submission of a resume by the applicant, their immediate supervisor completing a standardized reference form, the applicants participating in a digital interview in which they all answered the same questions, and their scores were ranked 1 through 5 by all principal within their respective grade bands. And then the principals who reviewed all of the interviews made their top 5 preferences ranking in order based on their review of the interviews and the resumes. The executive directors in central office considered all of that data that was used during the process and made a comprehensive recommendation to Dr. Bolson for placements for assistant principals at each school, which he accepted. Instructions on this process were well documented in PowerPoint presentations given to all those involved and in emails, and the district court found it undisputed that the decision makers considered in making the assignments the candidate interview scores, the top 5 lists from the principals, which were based on their review of the resumes and the interviews, and the supervisory references submitted on the standardized form for this process.
Interviews and supervisors' recommendations, right? You turn it into a beauty contest, basically.
Your Honor,
Isn't it? Because what you say is, well, we don't need to even look at your past performances, which I thought evaluations of past performances are very important. We don't even look at your tenure, necessarily your qualifications. That's what a beauty contest is. No, what your supervisor says about you and how you did at the interview. That's a beauty contest, really. And doesn't that hurt people who've been working there for a long time, doing well, and that somebody can come in who's been there a lot less and say, hey, we really clicked in that interview, and I really like you. That's kind of a beauty test. Because you just said we felt that you admitted that the normal RIF process wasn't done. We thought this is the best way to restructure them by making it almost 100% subjective. Interviews and recommendations from the supervisor and not looking at a continuum of evaluations over time. Isn't that the recipe for problems like this we have?
Your Honor, no, and the reason is because this court has repeatedly said that subjective factors are a proper consideration at the second stage of the McDonnell-Douglas test, especially when considering filling positions for upper-level management positions, and particularly so in the subjective
Have we ever said in the Fourth Circuit that, I know it's kind of tough, but that you can take a situation where a person has, just categories and qualifications off the chart, and then you could say, well, no, we have an interview process here, and this person interviewed better because they related better to the supervisor. The supervisor basically likes them more. And isn't that many times a detriment, many times, for people who have historically been left out of jobs? Isn't that one of the problems that, in the sense that, because we look at these sort of systematically, if you've been there, in terms of a culture and that kind of thing, don't you think you tend to do better in interviews with people who, isn't that one of the problems in this? And then you say, you can't point to anything that was wrong in this process. I know you can't, because we can't go back and say, I don't know how the interview went. I don't know how your recommendation went, but we can look at performance over time. So what I'm saying is, this is the case you're saying everything is fine, but it seemed to me you took out everything that's quantitative.
Your Honor, there was repeated testimony in the record that the past performance evaluation tool was not meant to be used in this context. Additionally, the interviews were standardized, and subjective criteria are properly credited at the second stage of the McDonnell-Douglas test, which the Supreme Court has said in Burdine is a very low standard, particularly when, as this court said in Love versus Alamance, that applicants are asked the same set of interview questions. They were scored on those questions. The same instructions were given to every participant. The supervisors used standardized reference forms and were instructed to use their best professional judgment. So was there subjectivity in the process? Yes, but there were elements of standardization.
You said it's the same question. It's amazing how you think that satisfies it. Okay, the question that was asked is, how do you think the Constitution has been honored through the history of this country? And everybody gets the same question. You think that equalizes it at all?
I think it's
no. I'm following what you just said. That's the question. How do you think the Constitution has been implemented or fulfilled in the history of this country? That's the question to everybody. And you're saying that equalizes the playing field, because then the supervisor says, I'm gonna weigh what your answer was in terms of which one I like better. I don't understand how in the world that does it, because you're saying, that's not objective at all, because just because the same question was asked.
Well, Your Honor, there was no evidence that I think it's undisputed, Your Honor, that the interview process was job-related. These are job-related questions, and they were scored on a 1 through 5 basis. It's also undisputed that the appellants, according to that metric, scored worse than their chosen comparators based on the metrics considered in this process. And there's...
What answers did they get wrong?
They were, it's not a wrong or right question.
I know it,
here.
exactly. That's the problem. There's no answers that are right or wrong. You just sit there and say, I like you, I like it better. That's the problem with that in terms of your reduction in workforce. You decided to put all those things aside and leave it to a process to say 1, 2, 3, 4, 5. In this record, you can't say what was wrong. That's why you need objective. They ask about pedagogical type certain things and that kind of thing. How the students are performing. Those are the kind of things from a pedagogical standpoint you would do, but just to sit around and say, okay, how did you answer this now? I get that a 5. You know, it's like those television shows, you know, people sing and you go like, raise your card up, 8, 9, you know, I don't know.
Yes, Your Honor.
What
and
is
so,
that?
back to your question to my colleague about, would the RIF process have resulted in any different? And the answer is no.
We don't know, do we, if we had looked at performance and overtime. You took all of those things that can be tracked and quantitative, you took them out. That's the whole point. I mean, history of employment, that's one of the biggest problems that Title VII tried to deal with.
And
in the
Your
sense
Honor,
that, they just didn't relate as much. I don't live in the same, people, for example, like somebody who, I'm from, town, small town. If I see somebody from my town, I say, hey, you from the same place. I relate. People relate to that. That's why we don't come here. And you said, well, this is objective because we had these subject, and you can't even tell me what the right or wrong. You admitted it right there. You said, there is no right and wrong. I'm glad you said that. I appreciate that honesty in that because that's exactly what the problem is. There's no right and wrong other than the wrongness that may be in the system that you put together in terms of who gets RIF, but not the test of whether or not you go forward. And that's a problem. That is a problem. And I don't know, I think this is a interesting case there because you admit these people spent all these years, and then you say, do you agree with this? Under your system, a person could be working for 10 years, doing well, perfect record. Another person could come in 1 year, but people like them more, and they like their answers. Do you agree with that? That could happen in your system?
yes, and I think that's a perfectly legitimate reason for selecting one candidate over another because seniority, Your Honor, doesn't necessarily mean that the person is performing better or demonstrates relative strengths and weaknesses compared to another candidate.
I agree with that, but it ought to be something objective to determine that it didn't.
And in this case, Your Honor,
That it didn't.
in this case, the relative strengths and weaknesses were judged. Like I said, there's not a right or wrong answer, but they can be judged on the relative strengths and weaknesses and their ability to answer questions that are directly job-related, and that's exactly what happened in this case.
Can I ask you about one individual, Ms. Bomar? My understanding is that one of your criteria for selection was the request or recommendation of the principal from the school, is that right?
Yes, Your Honor.
And Principal Quigg selected Ms. Bomar as his first and only choice for assistant principal, is that right?
So you're referring to the August 2019 opening at...
Did he request, did Principal Quigg say Ms. Bomar was his first choice for Aberdeen?
Initially, when he was asked to select a candidate, yes, he said Ms. Bomar. However, that was not the end of the process. The executive directors...
Why was his selection not credited at that point, when it was his first and only choice?
Well, because he hadn't gone through the process yet. The process said, we want to have you select 3 candidates.
But wouldn't that create a genuine issue of material fact with respect to that Ms. Bomar's situation?
Well,
I mean, you said there are objective criteria. There are 3 components of the RIF procedure. One of them is the request or the recommendation of the principal from that school. You have a principal from that school with a request, a sole request, and then that sole request is not honored. It seems to me that would create a genuine issue of material fact, at least with respect to Ms. Bomar.
well, the question is, does it create a genuine issue of material fact on that ultimate question of discrimination? And to that I say no, and here is why. the executive directors instructed Principal Quigg to look at 3 candidates to see who would be the best fit for that position. At that time, the principal of the school, Aberdeen High School, had a math and science academy. At that time, the record reflects that the principal was relatively new in that role, so it was important to the executive directors that they have someone with a math background to serve that interest. Additionally, so they looked at a few candidates, including Ms. Bomar, and the successful candidate was a woman named Manisha Thomas, African-American female. She not only had the math background, which Ms. Bomar did not, but she also was an administrator at Aberdeen Middle School, came from the communities, and knew the families well. So when looking at all the candidates, not just one in isolation, Ms. Thomas was selected over Ms. Bomar for legitimate, non-discriminatory reasons. And so, back to your question, Judge Berner, the evidence of the falsity of the explanation, I think, is a very surface level evidence of pretext that exists in this case, and I would submit that it doesn't, but it doesn't answer the ultimate question of whether or not there was a discriminatory or retaliatory motive. And this court's recent cases in Hollis and Wanamaker illustrate the very sort of evidence that is required to push cases across the line to demonstrate evidence of pretext and for a plaintiff to survive summary judgment, and it's very important. In Hollis, most recently decided by this court in August of 2025, this court vacated a summary judgment ruling of the district court in a sex discrimination case out of Morgan State University because the supervisor, who was directly involved in denying the plaintiff tenure and setting her pay, made blatantly discriminatory and derogatory comments regarding the plaintiff's sexual orientation. That was strong evidence of discriminatory intent, combined with evidence that the Morgan State failed to follow a tenure and promotion process, specifically as to the plaintiff in that case. Now, that's very different than the case we have here, where the initial decision was made not to follow a RIF process, which affected all applicants equally without regard to their protected status, and there's no other evidence of a discriminatory or retaliatory motive. In Wanamaker, Your Honor, the court also vacated a summary judgment ruling in a claim involving race and sex discrimination case. In that case, there was testimony that the plaintiff's supervisor expressed dismissiveness and disrespect towards women generally, and that he made an explicitly racist comment about the plaintiff specifically. That same supervisor had been trying to get the plaintiff fired for years and finally did so after blaming her for not responding to an email that she wasn't even copied on and not following the company's internal disciplinary procedures in the process of terminating her. This court found in Wanamaker that she established pretext upon which a jury could reasonably find that her acting supervisor harbored discriminatory animus towards her, built a case against her based on misleading allegations, and ultimately terminated her on unlawful grounds. This case is nothing like this court's recent precedent in Hollis and Wanamaker. There's very weak evidence of the falsity of the employer's explanations in this case, which I submit is only half of the pretext framework. There is no other evidence probative of a discriminatory or retaliatory motive. Indeed, the only evidence that my colleague points to, or argument my colleague points to, is the failure to follow the RIF process, which I submit affects all candidates equally. And as this court said in Wanamaker,
Do you really believe that the new system you put up impacts all employees equally?
The new system, Your Honor, was put into place at the beginning of the process.
How could that be? I mean, intellectually, you're a very smart lawyer.
Well,
intellectually, how could that be when you set up a system where I'm not going to look at performance over time, I'm not talking about tenure, I'm going to look at interviews and recommendations. How could that older employees who have good records over time would be, you think they're equally, wait a minute.
Sure.
You think that puts them on equal basis with the people who have been there 2 years and no real long track record? I mean, it hurts the person who's older, tend to be, or been there for a long, and you said it yourself, just because you've been there a long time doesn't mean you're good. I agree with you.
That's
but
true.
You ought to have a system that allows them to prove that over time that they have been good.
And
when you take that out, you hurt them. You can't get around that. You hurt them when you do that.
Well,
you
that's
definitely do. I mean, don't you? That's common sense, don't you?
Well,
If a person, let's take a factory job. You go in, that person been, breaking their back for years and something, working in labor and hard and lifting things, and men and women working hard, and you say, you know what, we're gonna decide who's gonna be foreman. But we're not gonna look at whether or not you know the job and you've done it well. It's just whether or not we have an interview and whether or not you answer questions, subjective questions. You think that that's equal impact to the people who worked hard for years, to the people who just walked in and hardly know how to get to the restroom in the cafeteria, could come in and say, you know, I liked them in the interview. And, you know, it's, you know, it was cool. You know, we like the same football team. You know, we go to the same club. Children go to the same soccer stuff. I mean, that hurts people who all they do is work hard for a long time. They're not in the social circles, whatever, but they work hard in that. And you said, that RIF system, we don't want that. You admitted it. You said, we move that aside. We want this. And I asked you about, I said, what is it you said? And you said out of your mouth, there's no right or wrong answer. It's just giving an opinion.
Demonstrating the relative strengths and weaknesses of each candidate to answer job-related questions. And one would think that someone who is very experienced in the job and performing well in the job for many, many years would excel in such a process, Your Honor. And so the process is designed to flesh out who is the strongest, who is the weakest, and who would be the best fit for a newly imagined role of assistant principal.
Oh, go ahead. I'm sorry. I'm glad you used the word to flush out. You said what? To flush out what?
Flesh out who the strengths, relative strengths and weaknesses of each candidate, which are legitimate, non-discriminatory reasons to consider in filling management level roles.
You didn't say flesh out. You said flush out, didn't you?
Flesh out.
No, you said flush. You said exactly. You said to flush out people.
No, I mean to elicit its responses from candidates to demonstrate their relative qualifications.
Okay, counsel.
And so, Your Honor, let me just close by stating this. This court's recent cases out of Hollis and Wanamaker demonstrate the sort of evidence that is required.
Your red light's on.
I see that. I will go, and I will ask that this court affirm the decision of the district court for the reasons I've stated and those in the record.
All right,
Thank you, Your Honors.
All right, Mr. McCormick.
Your Honors, I want to address a few of the points that opposing counsel mentioned. First off, the performance evaluations. I believe my colleague on the other side stated that the performance evaluations could not be used across all candidates and shouldn't be used across all candidates. However, included in the process that the defendants created was a supervisory reference. That supervisory reference had far less information that could be used by the decision makers, but it was used in place of a performance evaluation. The performance evaluation, however, the annual performance evaluation for the plaintiffs and for assistant principals, those are used for important purposes. The defendants concede that they were used for promotions, and that was one of the determining factors on whether or not an individual could be promoted. My colleague also mentioned that the plaintiffs were not, that the reason the plaintiffs were not selected is because they scored worse on the tools. That would include the interview scores, supervisory references, and the top 5 list. We know that Latina Hall and Robin Bomar, for one, scored well above the majority of the candidates in the process. But secondly, there was again, Your Honors, the defendants were not required to use any particular weighing of the factors which they used. So for the interview scores for one candidate, like Ms. Bomar, and what they did with her is she scored very highly, so the interview scores didn't mean as much. For other candidates, the top 5 list was the determining factor. You have a candidate like Anjanette Cook, who was, I believe, the lowest scoring candidate, and because her supervisor asked that she be retained, she was allowed to be retained. And this happened over and over again throughout the process. For some individuals, the supervisory references were the most important factor. It is very difficult to determine, well, first off, there is no determination because the process was completely arbitrary. You could use whatever factors you wanted for some candidates and other factors for other candidates. And also you could use factors outside of the process as well, because Rebecca Spencer determined that Jennifer Vlangas should be her candidate, even though she stated that she was not the strongest candidate. She still wanted her because she had a heart for the kids, and she liked her, and she would be okay with mentoring. Melissa McKay, she had the disciplinary issues, and she still was allowed to participate in the process. Drew Hoagland, his performance was average, and he only had an effective rating where my clients all had highly effective ratings. His interview score was far lower than Robin Bomar. He was still selected. Also, he was very inexperienced. He only held the position since 2017 and was a teacher prior to that. John Simpson was named in the top 5. He was one of Ms. Bomar's colleagues. He had testing issues. He still was selected. And maybe the most important one is Kim Marine. She was selected without having to participate in the interview process at all. As far as the considerations, the decision makers considered Zach Greenbaum, the fact that he had 2 little children, and consider his preparedness for a principal position. And Your Honor, I'm not saying that you cannot be compassionate with the employees. In fact, I believe that you should have compassion for your employees, and that you should consider them as total human beings. But it's discriminatory when you do it for some who are outside of the protected class, when they're younger, they're white, and they're male. But when it comes to my clients who were experienced African American women, they only considered their race, they only considered their age. And despite their experience, despite their performance, they were still demoted from their positions. So they had to go back to the school the next year in positions where people they had supervised were now supervising them. It was demoralizing, it was unfair, and it was illegal, and there's clear evidence of pretext in the record, Your Honor. So the decision from the lower court should be reversed, and on that I'll conclude.
All right, thank you. We'll come down and greet counsel and then proceed on to the next case. Next case we'll hear this morning is Metz versus McCarthy. And Mr. Crone, whenever you're ready.
Good morning. May it please the court, my name is Philip Crone. I'm here on behalf of the appellant plaintiff in this matter, Cheryl Metz. The matter before the court today involves Virginia state law claims that wound up in federal court on diversity jurisdiction. Specifically, the claim before the court today is a negligent repair claim under Virginia common law. On motion to dismiss, the court ruled in dismissing the case that entering a property for inspection is fundamentally distinct in nature from entering a property to repair.
Can we start with jurisdiction? Do we have jurisdiction?
Yes, Your Honor, you do. Here, the court had an order dismissing the negligent repair claim. It allowed the breach of contract claim to move forward, at which point Ms. Metz decided she did not want to pursue the breach of contract claim any further, and we, under Rule 41, took a voluntary dismissal as to that claim. The voluntary dismissal order does not include the term prejudice, which has brought the issue before the court now as to whether or not it is properly before the court.
You have asserted in your brief, I think, that you agree or stipulate that it was with prejudice.
Yes, there's no intention of bringing this back. And
can we agree that there's a stipulation that your dismissal was with prejudice?
Yes, I believe under Jones, that is allowed. They considered that.
Fair enough.
That it was. And again, so in dismissing the case, the court found that entering a property for inspection is fundamentally distinct in nature from entering a property to repair. And an inspection is the act of surveying and examining a potential issue to determine whether and to what degree a repair is needed. Inspecting is not the same as taking a positive act in conducting a repair, and that without any further actions to repair, a tenant cannot recover in the tort of negligent inspection. The issues before the court today are slightly intertwined. The first is that the court erred in holding that an inspection, which essentially turned into a term of art now, can never be the basis for a negligent repair claim,
Well,
and that it's
you don't even allege that the inspection, I'm not sure that's part of the repair. I guess it's preliminary to the repair. You have to decide what needs to be done and then write up a proposal and so forth. But even if you argue that inspection is part of the repair, you don't allege that the inspection was negligent. In other words, basically they came and looked at it and left, and nothing further happened. But you never got a report of what the inspection said, what they concluded, and how they reacted pursuant to it. I mean, what I think Virginia gets at is if they undertake to repair it and do so negligently, their cause of action could arise. But absent a negligent repair, they fall back on the relationship of landlord-tenant.
Yes, and to look at the way the Virginia Supreme Court has addressed the distinction for where you have a breach of contract claim and a tort claim, key part of that language, which gets repeated throughout, is that whenever it starts, it says, although a landlord does not have a common law duty to make repairs after delivering possession to the tenant, where the landlord enters lease premise for the purpose of making repairs, he must use reasonable care in performing that work.
In your cause of action, they acted negligent. The repair was negligent.
And so here, under the theory presented is that once she entered with the contractor, she did so with the intention of making repair. This wasn't a case
Well, how
where
do you
she's
know they
just
did?
because it's not a case where she's just under her landlord, her lease, where the landlord says, hey, we're switching from summer to fall, I'm gonna come in and do a fall inspection. She was notified of a problem. She made the decision to go, bring in a contractor, go to the premises, go in and look. At that point, her decision, which is alleged, is that she decided she was going to start repairs
How do
to
you know
finish
that?
it after.
How do you know that?
In the complaint,
Yeah.
it's alleged that it was informed to the tenants by her property manager,
What were they informed?
that she was not going to finish any repairs until after the tenants had moved out.
She didn't say finish repairs, they were gonna address it, address everything. She was going to let the lease run out and take possession of the property and address the matters generally about the whole, including that.
And had she not come to the house, I don't think I have an argument at all. I think that
All right.
if there's a request that there's a problem in the house and that it needs to be fixed, she receives it and she comes. She doesn't just come on her own, she brings a contractor, they look at it. At that point, she could have done other steps, even at that point. Oh, I'm not gonna address it now, I'm gonna board it up. I'm gonna tell you guys not to use this room anymore. There could be some steps in the way the district court looked at it was that they said there needed to be some sort of positive act outside. And again, relying on their definition that this was just an
There had to
inspection.
be some active repair.
Well,
In other words, the idea is that there had to be an active repair and it had to be done negligently
yes.
for you to have a
So,
cause of action.
and then we get a little further into then looking at then the definition of repair, because the Supreme Court
Well,
held.
not a condition, we just need to have an active repair that was done negligently. And we don't have an active repair, there's
What-
nobody even touched it, covered it, as you say, measured it, they just came and looked to see what the problem was.
And that's starting.
That's not the
Something
repair.
doesn't just,
All
you,
right.
you can't start to repair something if you don't know what it is you're repairing. Look, in Holland versus Shively, there's no repair done, they simply removed a step. And the court, that still went to trial. There was evidence, the court found that.
Well, they removed a step,
Well, is removing a step repairing? That's the opposite of repair, it's
it
destruction.
can be done negligently, create an unsafe condition. They came in and changed the property, right?
Correct.
Removed a step.
And here,
They did nothing.
they did nothing after they started to do something. Doing nothing would have been not responding, would have been immediately saying, I'm not gonna deal with that. That's the contract aspect of this, is looking
Well,
back
we don't-
at what
we don't have a
Virginia has said.
contract before us. We have a
Ex-
negligence case.
Exactly. And there is no duty to repair. Here, in the way the negligent repair cases look at it in the Supreme Court, they always talk about entering the premises. That's the first. When she comes to that house and enters and goes in to look at it, she's there to do repairs. She's not, at that point, she didn't enter that house because of a scheduled inspection like the district court. It creates this separation between the two in a bright line rule.
Well, counsel, since we're not in contract, what is it by coming to do the inspection that triggers the duty? And what is that duty? What is the fact that triggers the duty and what is the duty?
So, by coming into the house,
Okay.
after she's been put on notice, she's coming in there she's commenced the repair part. That's where, and once she starts
Coming
doing
in-
that, she has to do so with reasonable care.
Coming in through the threshold to look at it, that's what triggers the duty for
And here,
repairs?
it's, in addition to that, it's alleged that she didn't just come in by herself, she came in with a contractor. in the complaint, it's alleged that the contractor told her it's gonna be a complex fix, and it's alleged in the complaint that the tenants were informed she wasn't gonna complete anything on it until they left.
Looks,
When
sounds
she
to me
started-
like because he said it was complex, she decided not to repair it. In other words,
Well,
she might, if it had been simple, she might have undertaken repair, but she clearly undertook not to make a repair.
But she had started. So the question becomes is,
They didn't lift
was
a
it
nail
was
for
it reasonable was it reasonable for her to do that? Because she had already started. The district court short-circuited litigation by looking at it in favor of the defendant and saying, I think that these facts show an inspection and it didn't cross the threshold into what a repair started.
Your claim has to be undertaking a repair and doing it negligently. And the question here, and causing you damage. There was no change made to that skylight. There was no repair made. It leaked before they came, and it leaked after they came. And so there was no repair done, and nothing was done negligently. They decided not to repair it. You have to claim that they undertook to repair it and did so negligently.
And based on Virginia law, when she went to the house to investigate and start looking, she had started that repair. And it's a question of fact for a jury to decide if that's what happened when it
If
did.
there's nothing done, in other words, the negligence requires not only the actual undertaking of repair and doing it carelessly, but it caused injury. And there was no injury caused as a result. Injury is an element of negligence, and there was no injury caused by looking at it. You're saying
And
that's
doing
the
nothing.
repair.
There's an
You're saying
omission
coming in
here.
and looking at it is the injury. And the fact is, it leaked before they came, and it leaked after they left, and it was not changed by reason of their looking at it.
Well, leaking involves more than one thing. Involves moisture, which obviously can lead to mold and mildew and other health issues, which
That was
again,
that was the pre-existing condition. There was no repair.
and then what injured her was when water pooled from a storm and she slipped on it. And there was nothing, looking at the other cases where there was some sort of either demolition done or plywood put up, a cinder block put down. In some of those cases, and I believe it's Holland v. Shively, they're moving tenants from one house to another because of the conditions. Here, there's nothing. Negligence is not just a positive act. It's also the omission. Was it reasonable for her to, after learning that there needed to be
Because
repaired?
there's no duty to repair. Virginia says there's no duty to repair unless you undertake a repair and do so negligently.
And she undertook when she went to and entered the premises. She
Are
doesn't.
there
She
any
could have responded by saying that I'm not going to do it or I'm ignoring it, and I can't. There's nothing I can say to that.
Are there any Virginia cases that find entering a premises with a contractor, inspecting damage, but not undertaking any positive steps toward repair constitute an act toward the repair?
There's no case law, and here there's not any really Virginia case law that would make the distinction about the inspection versus the repair as the district court's opinion does.
It sounds to me like you alleged in the complaint that the inspection resulted in the decision not to repair because
Well,
it was too complex. You
it
quoted the guy saying, to fix it would be complex, right?
It resulted in the timeline that she decided
No, but
to
isn't that what
finish it.
you quoted the contractor?
Yes, the
said?
contractor said it would be complex.
Yeah.
And again, the contractor doesn't have any duties. He don't know what he was hired for. But here, deciding a timeline is part of repair. Businesses all the time create project management plans. They set timelines for when things are going to be done. Once they've started doing that, they've started the project, even if something's not going to be completed for another few weeks. Here, the allegation is doing nothing in that time, doing it finishing it at a later time. That is what we're asking a jury to be able to hear to determine if they believe that was negligence. I'm gonna reserve the
Okay,
remainder of my
thank you.
time.
Fine. All right, Mr. Trevette?
Thank you, Your Honors. Ed Trivett on behalf of the defendant, Lori McCarthy. Your Honor, have we dispensed with the jurisdictional issue? If so, then
Well,
I'll
as I understand it, he stipulated that his dismissal was with prejudice, and I think that would bind him on not being able to refile his contract case. And if that's so, then we would have jurisdiction, wouldn't we?
Yes, Your Honor, as long as that stipulation is binding, that's what my reading of the case law would indicate. So, Your Honor, with respect to the merits of the underlying decision, I think Your Honor's brought up a number of good points, and frankly, the timeline basically dictates, based on the allegations of the complaint, what was going on here. The plaintiff and her son lived there. They advised the league in March of 21. In June of 21, the contractor comes out with Ms. McCarthy, indicates it's a complex fix. No action is undertaken at that time. No action is undertaken, in fact, for the entire rest of the tenancy of the Metzes in that house, all the way into January of 2022. According to the allegations of the plaintiff's complaint, the skylight remained unrepaired. That's paragraph 17 of the complaint. There was no repair made. And then at basically the same time, Your Honor indicated, McCarthy indicates she's going to move back into the house and she will address the issues that the Metz's son had raised before they become bigger problems after she's taken back possession of the property. There was no affirmative step to engage in repair. The only action that is alleged in the complaint is that the inspection occurred. There is also no allegation that the inspection was done improperly. The only affirmative act being the inspection, and there not being any negligence attaching to the inspection itself, there is no allegation in this complaint of negligence by my client. I think plaintiff's counsel stated it accurately when he said you can't start to repair if you don't know what to repair. That's all they were doing. They were going there to see what the issue was. It could be condensation, it could be a leak, it could be something totally unrelated to the skylight just nearby. They were going there to figure it out. And that's all they did. Your Honor,
What else do you have?
What's that?
What else do you have?
Your Honor, I think Your Honor has hit upon the case law going all the way back to Odin versus South Norfolk, and then more recently the Stewart versus Holland family case, squarely on point. The common law duty actually rests with the tenant once the premises are demised to them, not with the landlord to conduct the repairs. It's only if they engage in the repairs and do them negligently that there is any duty there. The only other issue that I think was not really addressed, although we brought it up on the demur, was that the plaintiff was in control of this premises, and what she slipped on was a wet floor. Any wet floor in that house would have been her responsibility, her and her son's, to ameliorate. If any other person, any stranger to this process, not the landlord, not the tenant, if anybody else had come in there and slipped on wet floor in the kitchen, it would be the responsibility of the tenant for failing to remedy that. Here, the plaintiff was responsible for remedying whatever condition was existing on the floor. And so, Your Honor, I would think that we argued previously that she was barred by contributory negligence as a matter of law as well. Unless Your Honors have any questions for me.
All right, thank you.
Thank you.
Mr. Crum?
Thank you. To not belabor the points already made, I did just want to touch, the Virginia model jury instruction says a landlord who undertakes to make repairs has a duty to the tenant to use reasonable care in making them. Again, looking at the undertakes to make repairs, it's that they're putting oneself under the obligation to perform. Here, going back, and I know I've said it again, and I'm going to say it one more time, entering the premises is what shifts this over from breach of contract to tort. She enters the premises, she's started the process, and now it's a question for a finder of fact to determine, no, there's absolutely nothing negligent with coming in, looking at it, and then waiting to do something. if that's the case, that's the case, and a jury finds against
Okay.
my client. For those reasons, we'd ask that the court reverse the motion to dismiss and remand this case for further proceedings. Thank you.
Thank you. We'll come down to Greek Council and proceed on to the last case. All right, the last case we'll hear is Guzman versus I guess that's Aquarius nightclub, spelt in its peculiar fashion. And Mr. Golozewski, we'll hear from you first.
Good morning, and may it please the court, John Golashevsky on behalf of the appellants. The question before this court is a exceedingly straightforward one. We lay it out in our papers. Did the district court err in granting respondents' motion to dismiss exclusively on the grounds appellants did not file an opposition? It's exceedingly straightforward because this court has twice answered this exact question. Once in 2014 in Stevenson, and last year in Gowdy, and I think Gowdy is worth quoting. Quote, a district court is obliged to review a defendant's motion to dismiss and ensure that dismissal is appropriate even where, as here, plaintiff fails to respond to the motion. Although the district court may dismiss an action on the uncontroverted basis asserted in the motion, it still must review the grounds presented in the motion.
Well, the long and short of it is that there's no default motion for summary judgment or default motion to dismiss or default motion for judgment on the pleadings.
That's
We've
exactly.
written this up in summary judgment area too. I mean, the idea is if somebody doesn't answer or answers inadequately, the court still has to decide the motion. And the motion here is the sufficiency of the complaint.
That's exactly right, Your Honor. Considering all allegations in the complaint and the light most favorable to the plaintiffs, considering in this case 120 advertisements containing my client's intellectual property, but Your Honor is absolutely correct to do otherwise, to grant it as unopposed. And let's be clear, in light of respondent's argument, there is nothing in the record to indicate the district court reviewed any aspect of this case, either the motion or plaintiff's complaint, quote, text order, granting as unopposed. And we can contrast this to case after case after case in this circuit in which a plaintiff has not responded to a motion to dismiss, and the district court says, even though there is no response, under Stevenson and more recently under Gowdy, we nevertheless need to consider the entirety of the motion and the complaint, and then goes on to issue a 5, 6, 7-page decision. We cite the Parks case, and here there are reams of other cases on this point. To, as Your Honor says, to dismiss this case on the ground as unopposed amounts to a procedural default, amounts to a sanction against the plaintiffs, and this is the exact opposite of what this court has said. Briefly, respondents offer 3 arguments.
Can I ask you
Of
that
course.
in the text order, the district court indicates that certain claims are dismissed with prejudice and certain other claims are dismissed without prejudice, and then there's a declination to exercise jurisdictional, supplemental jurisdiction over, I guess, a final claim. Do those different dismissal postures indicate that the district court did in fact engage in and consider the merits?
Absolutely not.
Well,
There's nothing
what would be enough?
and if I just may, the reason is because they did not move to dismiss the state misappropriation claim. That is the claim that was dismissed without prejudice, and the district court decided not to exercise supplemental jurisdiction. The answer is, I don't know what enough would be. Enough would have to include analyzing the specific allegations in the complaint, assessing the law, setting forth that under Rule 12, the standard is to construe all allegations in the light most favorable to the plaintiff, and so forth. I don't think we can set, it has to be 5 paragraphs, 10 paragraphs, 20 paragraphs. But what I do know is that when an order sets forth that a case is dismissed, quote, granting as unopposed, that there is nothing in the record, and that's what we care about under Gowdy. There is nothing in the record to indicate that the district court did any of these things, that it ever reviewed the complaint, that it ever reviewed the motion, and that's the problem under Gowdy. 3 arguments that the respondents make. The first, and I think we just touched on it, is that the district court did in fact review the motion and the record, did in fact review the motion and the complaint and all the record below. I'm not saying that the district court didn't. I have no idea. All I know is what the record says. And the record does not say we are dismissing this complaint because of a failure to plead a Lanham Act claim, for a failure to plead negligence, et cetera, and so forth, which is what you would expect. All it says is granting as unopposed. The second argument is that the local rules of South Carolina, quote, require a response to a Rule 12 motion. We lay out the local rules. They don't say anything relating to that. There is no requirement whatsoever. What they say is that if a Rule 12 motion is not opposed, then the district court will review the motion on the record. Completely aligns with this court's decision in Stevenson and Gowdy. There is no obligation for a plaintiff to respond to a Rule 12 motion. Third, they made the argument primarily at their motion to dismiss the complaint, that there was some obligation to file a motion for reconsideration. It's an affront to Rule 59 and 60. It's an affront to Federal Rule of Appellate Procedure 3 and 4, the idea that there is now some additional hurdle that a plaintiff or any party needs to overcome before they can avail themselves.
Well, the post-trial proceedings in this were totally, messy, so to speak.
I do not disagree.
But the dismissal judgment was entered on the 12th, and you filed a 60B motion on the 15th, and that was decided in June, and 2 days later you appealed. It seems to me that's pretty pro forma.
We agree, Your Honor. Unless anyone has any questions.
Okay, thank you very much.
Thank you.
Mr. Barber.
May it please the court, Philip Barber for the Appalachee Curious Nightclub. I believe as a threshold issue here, if we refer to this issue of whether or not the district court actually looked at the merits before dismissing, if maybe refer to that as a Stevenson issue. Before getting to that, was it preserved? That issue was never
Doesn't need to be preserved. It doesn't need to be preserved. A judgment's a judgment, and you can appeal it. If it's wrong, we'll reverse it. There's no post-trial motion that has to be filed. It's totally voluntary on his part, and he'd take a shot on reconsideration for different reasons. But he timely appealed the judgment. The judgment was April 12, and he appealed on June 13, 2 days after the court disposed of his post-trial motion. All the rest is irrelevant. We have the judgment before us, and he says it was wrong because he says the court decided it as a matter of default. And I think that's the issue before us.
Very well, Your Honor.
But where do you get some authority that he has to file a 60 motion or a 59 motion?
Well, 2 sources, Your Honor. Specific to this posture, the First Circuit, of course, has ruled on the general rule that's true everywhere, that you cannot argue something on appeal in the first instance, that you have to make some argument below before you come say that the court's ruling was incorrect.
The court entered a judgment against the plaintiff because the plaintiff didn't respond and said because there's no response, it's dismissed. That's what the district court did. That's a final judgment. And they're appealing that judgment, and they didn't, it seems to me, every issue encompassed in that judgment's on appeal.
Yes, Your Honor.
I mean, they didn't even get a chance to respond. Now, they did file, well, they were untimely, but they did file a Rule 60B motion. Court denied it, so they appealed the judgment. They can do that.
Yes, Your Honor, and getting to that issue, first, the record does have indications that the district court did, in fact, look at the merits. It looks
to me like it relied on the fact that there was no response. Now, Now, show me otherwise. Looks to me like the district court said they failed to respond as unopposed, therefore, she granted it, which is a notion of default motion, and of course, the rules require to grant a motion to dismiss, you need to test the sufficiency of the complaint, the legal sufficiency of the complaint, or a summary judgment that you're entitled to judgment as a matter of law.
Yes, Your Honor. For evidence that the district court actually read the motion, there is the fact that some claims were dismissed with prejudice. It's not the case that the defendant did.
Well, there was, wasn't that the issue for whether the court's going to retain claims? I mean, the court didn't want to retain state law claims, right?
Yes, Your Honor, and that was in the motion.
Yeah.
The defendant moved to dismiss those claims without prejudice, arguing the court should decline supplemental jurisdiction. That was part of the motion. The court clearly read the motion and distinguished between the claims that were dismissal was sought with prejudice from claims where it was sought without prejudice.
It may have read them. It may have considered it. The court may even thought it was a lousy complaint. But the court didn't say that. The court said it's unopposed, therefore I'm granting it.
Yes, Your Honor, and if I may, on that point, on another issue of preservation, it is usually the rule that if everything is here, there's a judgment, everything encompassed in a judgment is on appeal, there should be some showing in an opening brief about why, if that error did occur, why it's not harmless. You know,
There's no harmless error issue. The question is whether the court can dismiss a 12b6 motion without considering the sufficiency of the complaint. That's the issue on appeal. Now, there's another issue on appeal he could raise, is should the court have reopened the judgment because of attorney error. He can argue that too, and we could send it back on the basis of that. Maybe the court abuses discretion in not opening the judgment because of attorney error. I'm not sure what the error was.
Respectfully, Your Honor, he did make that appeal.
They didn't put it on their docket, or they misread it, or didn't catch it. It seems to me if notices are given these days electronically, you could argue that, well, the power was out in my chambers and I didn't get it or whatever. But he could raise that too. That's part of the judgment. He could raise anything on the appeal that was disposed of in the judgment.
He did make that appeal, Your Honor.
Yeah,
There are 3 notices of appeal in this action. There's the appeal from the judgment.
Those are subsequent, and they're really, we have jurisdiction over this case because of the appeal on June 13.
Yes, Your Honor, but to be clear on the record, the point that Your Honor just made, that he could have raised those issues about attorney error, he did file a motion, a Rule 60 motion, making those arguments, and when it was denied, he did notice an appeal that's before the court now. As I noted in the appellee's brief, he abandoned that argument.
But that appeal is an appeal not from the 60B. It includes the 60B, but it also includes the judgment. The appeal is from the final judgment dated April 12th.
Yes, Your Honor.
That judgment was, and he's challenging that judgment on appeal.
Yes, Your Honor, a Rule 60B appeal.
It's straightforward. You're interposing all these almost common law traps. He didn't answer the complaint. The district court disposed of it because there was no response. And he then came in and said, I'd like to reopen it because I made a mistake. And the court said no, and he appealed. Now, when he appeals that, he gets to appeal both the court's decision and not reopening and the judgment itself.
Yes, Your Honor, he noticed both of those appeals timely. Yes, Your Honor.
Yeah. So I don't know why we fight over that. It seems to me the argument you're making is that the court could have read the complaints, and it's indicative that she did read the complaint because some of the cases were without prejudice, some of the claims. But that was with respect to the exercise of supplemental jurisdiction, wasn't it?
It was, Your Honor. It's all in the same motion. There's one complaint and one motion to dismiss, which the court read as indicated by the ruling, which followed the relief being sought for the reasons being sought in the motion.
But there's no evidence that the court, with respect to the federal claims, there's no evidence that the court considered the sufficiency of the complaint, the legal sufficiency. And that's what a 12b6 motion raises.
Yes.
You can only grant a 12b6 motion if the complaint is legally insufficient. and you can deny it if it's legally sufficient. Now, she granted it, and so she could only do so if she had concluded that it was legally insufficient. It looks to me, on this complaint, on this record, that she did not consider that. She considered the fact that there was no response and therefore was unopposed. Isn't that what you read from her writing?
No, Your Honor, because those claims, certain claims were dismissed with prejudice.
Okay,
And there are plenty of cases that stand for the principle that a dismissal with prejudice is on the merits. The fact that she made that election on some claims and not others indicates consideration of the merits.
Okay. Thank you.
And if I may make one last point, Your Honor, even on remand under the local rule and decisions of this court, it's the court's discretion whether to allow a memo in response. If there is an error, that it may be that the court needs to issue an opinion explaining the ruling that it made earlier.
The sanction for not responding to a motion to dismiss is not to dismiss the motion. The sanction for not responding is that he has taken himself out of the picture.
Yes, Your Honor, absolutely.
So he can't make the argument, but the court still has to satisfy itself that the motion should be granted.
Yes, Your Honor.
And so if the court erred in that, you open it up again, and the court would have that motion before her, and she could consider it. They file their responses and so forth.
Yes, Your Honor, I was simply making the point that the error would be to not explain the reasoning for the motion and to engage in the analysis if in fact it did not occur the first time, but that there is not a right under the rules to reopen the briefing on the motion and receive a response. That would be within the district court's
Well, if the
discretion.
judgment is vacated, then the district court has before it a motion, plain motion, and
Yes.
how the court handles it thereafter will be up to the district court. Would be, wouldn't it?
Absolutely, Your Honor. Thank you, Your Honor.
Yeah. You got anything further?
Very briefly, Your Honor, I think Your Honor understands I'm not here on any merit-based appeal whatsoever. It's not coming into the picture. We are here exclusively on the issue of whether the district court erred in granting the motion as unopposed. In our reply brief, because counsel alluded to this First Circuit authority, the First Circuit in the Jones case acknowledged that it is, quote, out of step with every other circuit in the country, but then went on to say, still, in order for dismissal for failure to respond to a Rule 12b6 motion to stand in this circuit, the relevant local rule generally must impose a mandatory requirement to file an opposition. And of course, the District of South Carolina has no such mandatory rule. I think also it's worth noting—
Well, there may be a rule, it could be a mandatory rule locally imposed to answer the motion, but the failure to do that is not to default. I mean, we have a concept of default judgments where somebody doesn't answer, but we have a whole process that involves that, and the person put on notice, if you do not answer this complaint, default judgment will be entered against you. And then the person comes in and can set it aside under established procedure. But the complaint, unanswered complaint, is different from a motion that challenges the sufficiency of the complaint or the legality or a matter of law under Rule 56. And I actually wrote an opinion a while back, said there's no such thing as a default judgment under Rule 56.
Right.
Because the rules require the court to consider different issues, whether there's this issue of fact and whether you're entitled to judgment as a matter of law. Here, it's the legal sufficiency of the complaint on its face.
that's exactly right. And I think the court understands this. Thank you very much.
We'll adjourn court, sine die, and then come down and recounsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.